Okay.
Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This is another one that everyone knows because this, kids, is your Miranda rights, or at least part of them.
Another court case happened with this.
Yeah. So speedy is, depends on your terms. The criminal justice system is a mess. The public defender's office is horrifically underpaid and understaffed and overworked. So speedy and public trial is going to depend on somebody's calendar.
For your court, it's probably speedy, but I doubt it's public.
Well, our court, when I did jury duty.
Well, I meant the court of your house.
Oh, the court of my house? Yeah, no. Court of my house is private. We have a star chamber. We don't have a jury trial. Speedy, yes, they get tried right away. They get tried faster in my house than they would, in a court of law. When I did jury duty, theoretically, any rando off the street could have walked into that courtroom and sat down and watched proceedings. You have that legal right. Now, how big a deal the case is going to limit how many seats there are in the courtroom. Public does not guarantee that it will, for example, be televised or that cameras will even be allowed in the courtroom. And cases involving juveniles are not public. Juvenile court is private to protect the rights of children. And I think we're all okay with that.
Oh, there was a case about juvenile court. That juveniles have the same rights in the Bill of Rights as adults do. There's a case.
Yeah. The only part of this that does not apply to juveniles is the public part. Family court is closed.
So I forget what case it was, but this kid got arrested for making prank phone calls, and they didn't give him a lawyer or anything. This threw him in jury for 10 years. And they said if it was an adult, it would be a $50 fine, but he was a juvenile, detention.
One of the many problems in the Exonerated Five case, what used to be called the Central Park Five, is that they were not given access to lawyers. Most of them were juveniles, and their parents weren't allowed to be there because if you are a minor, it's not just your legal right. They are obligated to let your parents be there. They're legally not allowed to question minors not in the presence of a parent or guardian. And the argument was, well, they said they were adults. So yeah, there's a lot of problems with that case, and I recommend learning more about it. There's a Ken Burns documentary about it for starters.
That reminds, thinking about that, would that mean I think in the movie No Way Home, weren't all three kids still minors when they were being questioned by the police?
Yeah, that's illegal. There's a certain amount of, exigent circumstances seen of the crime, but once you're brought in for questioning, if you are under 18, they have to have your parents there with you. And okay, in Mary Jane's case, that gets complicated. In Peter's case, obviously not his parents, but that means Aunt May is legally required to be there before he can be questioned because she's his legal guardian.
Then it says an impartial jury of the state.
An impartial jury of the state and district wherein the crime shall have been committed. And this is my jury duty experience again. The crime happened in the city of Tumwater, which if you're not local, you haven't heard of. It's fine. But it is in the same county that I live in. So it went to the county courthouse, and they hauled in like 50 or 60 people and went through a process to find out if we were impartial. And as I said before, there was a guy who, when asked if he could give, because they asked all of us, they didn't do individual questioning for the most part, but they asked all of us if we thought we could render an impartial verdict. And one guy raised his hand and said he absolutely could not, because he had too many female friends who had been abused by their male partners. And we knew that it was a case involving a restraining order and violation of a restraining order. He said, I can't be impartial in this case because I have friends who were severely injured when their restraining orders were violated. I can't be fair. And he was released because they wanted us to be able to say, yes, I will hear the evidence and I will weigh it fairly. And the District of Thurston County had been previously ascertained by law. Thurston County was a thing where he was going to be held and tried, because Tumwater is not big enough to have its own courthouse.
All right, and the next one is you get to be told why you're being arrested.
Yeah. And this one was, again, this was a huge issue in English law. There are lots of cases. And I don't think they were, modern to the founding fathers, but there were lots of cases of people being locked up for, in some cases, years without being put on trial or even told what they were doing there. There's actually law in the United States about how long they can arrest you and hold you without charges. I don't know if it's actually 72 hours in all jurisdictions, but it's another thing that you see on a lot of crime shows is, I can hold you for 72 hours. Good and tight. And at that point, they have to let you go. Either charge you and get an indictment or let you go. Because there was this experience and I'm pretty sure it even happened in what is now the United States, and it just wasn't common to arrest people and throw them in jail because reasons. What reasons? We're not saying. So when, to go back to my beloved Perry Mason, when Lieutenant Trying says, you're under arrest for the murder of this week's victim, he's got to say what the person is being arrested for. To get to the next clause, to be confronted with the witnesses against them. There are incidences where sworn statements are accepted, but this is why most of the time that's not what happens. Most of the time people have to come into court and the witnesses have to be in the room and say, this is what happened. This is the evidence I have to present that is relevant to this case. And then compulsory process for obtaining witnesses in his favor. You've heard the word subpoena. Let's say that someone is arrested for a crime. And it's someone you don't like very much. But you happen to know for a fact evidence that proves that they're not guilty. And let's say you don't want to come forward because they're an abusive dirtbag and you don't care if they're in prison or not. Their lawyer can still present you with a subpoena and compel you to give your evidence.
So,
and if you don't, you're in contempt of court.
So it can be both ways. One, you can if someone, you can call people to testify for you, but you can also question the witnesses against you.
Yeah. This is why our trials look the way they do, is by and large the Sixth Amendment. So you have Hamilton Berger and Perry Mason. You have the prosecutor bringing forth all of these witnesses. And then you have the defense attorney questioning all of the witnesses and finding out if they're biased, if what they're saying could have a different interpretation, if they're lying, if they're just honestly mistaken.
And the second half is to have the defense attorney call witnesses.
Yeah. And oddly, that almost never happens on Perry Mason. 90% of his cases are solved during the prosecution's part of the trial, but you see it a lot more on, for example, Law and Order. You see the defense witnesses. And you see Jack shouting at the defense witnesses because that's what Jack does.
Because Law and Order is the main character is the prosecutor, and then Perry Mason, the main character, was the defense attorney.
Right. One of the things I really like about Perry Mason, incidentally, is that the prosecuting attorney is not the villain. He doesn't always like Perry, but he's repeatedly shown to be quite happy that Perry got his client off and found the person who was actually guilty. Because what matters to him more is that the correct person be found guilty of the crime. He said it on multiple episodes.
You ever played the what's it called? Phoenix Wright series of games?
I've not. I'm familiar with it, but I haven't ever played it. Ace Attorney.
Yeah, only one time that I know of did he actually God, being the lawyer of the actual
was his client guilty?
Yeah, technically he was guilty of paying him off because technically his client didn't kill the guy, but he paid the guy that he paid the killer.
Well, that's that is guilt of murder. And of course, the Ace Attorney games are Japanese law, which is a whole different set of rules. Though I'm pretty sure a lot of Japanese law at this point is based on American law because of that whole World War II thing.
Yeah, but it was funny at the end. He confessed the crime because, even though he was a lawyer, but he confessed the crime because, Phoenix made it public that his client betrayed the killer and was trying to blackmail him. So the killer was like, "Oh, I no longer have I no longer have a contact with this guy anymore."
Yeah,
and he's like, "Oh, I'm guilty. I did it. Throw me in jail."
And so you have to you have the right to have an attorney help you with your defense. And in our current system, if you can't afford an attorney, one will be provided for you at public expense. Now, the attorney we're going to provide for you is underpaid and overworked, and probably has about 15 to 20 other cases that they're trying to get out the door as quickly as possible, and they may pressure you into a plea deal that is not in your best interest, simply because they don't have the time to properly defend you.
That would be Gideon versus Wainwright.
Yes, Gideon versus Wainwright. Establish the public defender system as your absolute legal right in the United States. There's a movie about it starring Henry Fonda, of all people, as Gideon. I believe it's called Gideon's Law. And we need to fix our public defender system. But the fact is, we have one. And that is something we as a nation should be really proud of. And again, that is for the guilty as well as the innocent. Guilty people have constitutional rights. They have the same rights under the Bill of Rights as every other American. And if they don't, then none of us do. Because the whole point of this is to figure out who's guilty.
Do Sandy and Zane have the right to a lawyer in the court of your house?
I mean, I'm not sure who they would find. Honestly, I can see one of them arguing on the behalf of the other, but in practice they wouldn't. And 9 times out of 10, the only other one in the house who will take their side is one of the cats, and they are not effective counsel. Because he's been found to have the right to not just counsel, but effective counsel. A lot of appeals happen because the lawyer in question screwed up somehow. And if your counsel can only say "meow," that's not effective counsel, because that is not an argument I am prepared to accept.
Be like, I never thought about that way. Innocent.
Yeah, oh, that's a good point. But have you considered "wow"?
So would in your court, would the grandparents be appeals court then, or?
Well, the kids really only have one grandparent, and they don't see her very often. The attempted appeals court in this household is the other parent. Presumably, the Supreme Court would be both of us talking to each other about things.
Has the appeal ever went through?
There have been 1 or 2 appeals that were successful, but it's always in the case of extenuating circumstances. Like, yes, this thing got broken, however. And pretty much every time, I'm the appeals court.
So your husband's usually the first judge, and then you're the appeal judge.
I'm usually the first judge, but he's very disinclined to overturn my decisions. Because I'm here most of the time. He works, and he works swing shift, which means that he doesn't get home until after the kids are supposed to be in bed. So he doesn't see the offenses most of the time.
So what would the Supreme Court case, your Supreme Court case, be then? Or what would it be called?
I think our Supreme Court is parental conference.
I mean, would the case be called like Zane versus Cookies, something like that, or Zane versus the Cats, or
is probably Zane versus his sister most of the time.
Be like call the case back. Yes, according to Zane versus Sandy 2.
Yeah,
we can do this.
Yeah. Well, yeah, it's well, but I think, but I say that she did it, or I say we had this agreement and she went back on it, and what have you. Sometimes it's Zane versus the need for a nap, or Zane versus the need for a cool down period, or what have you, because he does have some mental issues that mean that he escalates really quickly. And sometimes it's like, he didn't mean to do that, and it wasn't that big a deal. It was a purely accidental effect of this other thing he was doing. But most of the time, it's like, yeah, you know what? You're still guilty.
That's just still I don't see like that.
Well, the kitten is being kittenish, so.
Oh, so it was an awe thing, not like an O thing. Like,
yeah, it was an awe.
But sometimes she steps on your keyboard.
Yeah.
Sorry.
So the cats have a right to trial?
The cats have no right to trial. Most frequently, it is Phoenix v. Mouse's ear.
Or tail.
Or tail or leg, because she likes to attack him, and he is so done with this. She's still in the age where jumping and playing is part of affection, and he is not. He's only like 35 in cat years, but he acts like a grumpy old man. It's really funny.
But Phoenix, he's still a kitten.
She's still a kitten.
So
We've only had her for a couple of months.
So then they get a parental right then to juvenile court.
Yes.
All right. Anything else to talk about this case?
Nope. Sixth Amendment is pretty, it's very, very important. And a lot of nuance gets nosed around, like, effective counsel and public defenders and things like that. But it is, right now, the biggest issue is probably the speedy and effective counsel issues.
And so far, all these have been long ones. That means they discussed these at length.
They discussed these at length, and they wanted to make sure that all of the important stuff that you needed as an accused individual was in them. Because a lot of what we're dealing with right now is criminal protections. They wanted to make sure that the government didn't have the power to imprison you on a whim, which happened less often in the colonies than it had in a lot of other times in British history, but still happened sometimes.